Welcome to Where's Your Will, a series of programs where Bernalillo County Probate Judge Cristy Carbón-Gaul breaks down legal estate planning topics for your consideration. Thanks for joining us again, Judge.
Thank you.
In our last installment, we discussed the difference between wills and trusts. Today, we're going to discuss what happens to a person's assets if they die without a will or a trust. Judge, when this happens, who becomes the executor?
So all of the states have what's called, well, in New Mexico, it's called the Uniform Probate Code. It's statutes that fill in the gaps when someone doesn't have a will or a trust in place. And so the executor is going to be established by statute. Who has priority? Your spouse, your adult children, then it goes to parents and your siblings.
Who are the beneficiaries in this case?
The beneficiaries would be a spouse if the person that died was married. That would be 100% of the community property. If that person had separate property, which would be the assets that they inherited or that were gifted to them, or assets that they had before marriage, those go 75% to children and 25% to a spouse. If someone's not married with kids, then it goes to their parents, then to their siblings, and then to their nieces and nephews, if their people are deceased in those levels.
What if you have minor children?
Not having a will with minor children does cause problems. Then you would have to go to the district court to ask the court to appoint someone to be the guardian of the minor child. And then you also have to have somebody who's appointed to collect the assets for somebody who's under the age of 18.
Thanks, Judge. Great information as always.
Thank you.
And thank you for joining us. We hope to see you for our next installment where we discuss titling of assets.